Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. Trust has not been tested as frequently in recent years as it was in the past, but that doesn't mean you should ignore this subject. In this section of the guide, we will cover some tips to help you succeed on a trust essay should this subject come up. First, know how trust is tested. Unless you're instructed otherwise, you can usually apply general law on the trust essays. California's trust code is substantially similar to the majority law and also the Uniform Trust Code, which has been adopted by most states. So there aren't really many distinctions that you need to be aware of here or that you would need to apply. Also, trust has only been tested as a standalone subject a few times. Usually it's tested as a crossover question. Most commonly, it is crossed over with wills. Sometimes we will see trust crossed over with something else, such as wills and community property. So that's something else to be aware of. Next, be aware of the highly tested issues in trusts. One of the issues that we see frequently tested is trust validity. There are 5 requirements of a valid trust. 1, it has a trustee. 2, a beneficiary. 3, it has trust property. 4, the settlor has present intent and capacity to create a trust. And 5, the trust is created for a valid purpose. I have a couple notes about these requirements though. First, a trust will not fail for lack of a trustee. The court will simply appoint someone to serve as the trustee if a trustee is not named or identified. Second, with regard to the beneficiary, the same person cannot be the sole trustee and the sole beneficiary. The trustee owes fiduciary duties to the beneficiary, and the beneficiary holds the trustee accountable. So if the same person is the sole trustee and the sole beneficiary, there's no one to hold the trustee accountable. Another topic that frequently appears in trust essays is different types of trusts. You may have to identify what type of trust is at issue and the requirements for that particular type of trust. For example, you might see a testamentary trust or a charitable trust tested. A testamentary trust is a trust that is created within a will. To be valid, the essential elements of the trust must be ascertained from the terms of the will, an existing writing incorporated into the will, or the exercise of a power of appointment created by the will. In a question testing this issue, you would also likely have to discuss the validity of that will. So this is a great example of an issue that could appear in a wills and trust crossover question. Another type of trust you might see is a charitable trust. A charitable trust can be created for various purposes, such as the relief of poverty, or the promotion of education, or religion, health, science, literacy, or government purposes, things like that. Many times when charitable trusts are tested, the doctrine of cypre is also tested. Cypre only applies to charitable trusts, which is why these topics often go hand in hand. Under the doctrine of cypre, if a particular charitable purpose has become unlawful, impracticable, or impossible to achieve, and no alternative charity is named in the trust, and if the court finds that the settlor had general rather than specific charitable intent, then the trust will not fail. Instead, the court will modify the trust and dictate that the trust property be applied or distributed in a manner consistent with that settlor's general charitable intent. So for example, let's say a woman sets up a trust for the benefit of orphaned children. So she leaves a substantial trust fund to a local orphanage. However, at the time of her death, when the trust would become effective, the local orphanage no longer exists. So if the court finds that the woman had general charitable intent, meaning that she just wanted to help orphaned children in general, then the court could modify the trust using Cypre and, for instance, find another orphanage to receive the benefits of the trust. On the other hand, if this woman picked this specific orphanage for a particular reason, such as that she herself lived in that orphanage as a child and so she wanted to give back to that specific orphanage, then the court will not likely find that general charitable intent and the trust would likely fail. If the trust fails, look to see if there's an alternate beneficiary. If there's not, usually the rules of intestate succession will apply to determine how the property would be distributed. Another highly tested trust topic is duties of the trustee. I mentioned previously that the trustee owes fiduciary duties to the beneficiary. The beneficiary can sue the trustee for breach of those fiduciary duties if the trustee does not abide by them. The trustee's duties include a duty to administer the trust in accordance with its terms, the duty to account, the duty of care, and the duty of loyalty. Our next tip for trust is to be aware of key trust vocabulary. Some of these words might be new to you, and knowing what they mean and how to use them will make your answer seem a little bit more polished. Some of the words you should be aware of include, first of all, settlor. This is the person who creates the trust. Beneficiary is the person who benefits from the trust. The trustee is the person who manages the trust. A testamentary trust, which we already discussed, is a trust that is created by a will. A pour-over will is where the trust that exists on its own, but the will pours a gift into the trust. The difference between a pour-over will and a testamentary trust is that the will creates the testamentary trust, whereas the trust in a pour-over will situation is separately created from the will. The will simply pours money into that pre-existing trust. The final tip for trust is to practice. Writing answers to trust practice questions will help acquaint you with that terminology and also the rules that often get tested within this subject. Also, given that this subject is frequently crossed over with wills, be sure to practice some crossover questions so that you're prepared for the types of issues you might see in a wills trust crossover. We recommend that you start your practice with the essays from February 2019, February 2016, February 2015, and July 2014.